And I know you, Carla, are from Oakland, so we have people here from kind of all over the state of California. So thank you so much for joining. I am going to say I am at home and I have two small kids. So if
Mhm.
we are interrupted at any point in time by two little ones popping in, you may see this hand push them out of the window, but they are very photogenic and they like to see themselves on camera. So just FYI, don't be surprised. Um, so my name is Nikki. I've been with the agency for 16 years now. I've been in this role for just about a decade. I love doing outreach and education. I love doing public relations and press, and just really like getting an opportunity to come out and talk to people about what the agency does, how we were born out of the civil rights marches, how it was the work of Martin Luther King and everybody else that really created this agency that gave us the mission that drives us every single day. And that even as things change, we are still here on the ground, really working to create workplaces that are free of discrimination and harassment and retaliation. So today we're just going to spend a little bit of time just talking about what the EEOC does for those of you who may not know, and how to go about filing a charge. And then hopefully I can answer any questions that you have. I love a good discussion, so definitely feel free to use the chat if you're able to. I see a couple of people are in cars, so you may not be able to use the chat. Feel free to take yourself off mute and say, "Hey, Nikki, I got a question. Can you clarify something a little bit more? Just need a little bit more understanding." But today really is a basic overview of what we do. If you've got deeper dive questions or specific questions about a situation you're in, that may not be appropriate for kind of this larger session today. My email address, I'm going to make sure that you all have so that you can always reach out to me directly. We can schedule a time to chat where we can talk a little bit more about your specific situation. I can give you guidance, but I'm not giving you legal advice. So that's the first thing I'm going to do today is give you my disclaimer. Everything we talk about today is for educational purposes only, because that really is my role. I am not an attorney, though I have spent almost 2 decades doing employment law. I'm not a lawyer, though I joke I could play one on TV at this point in time for as much as I know about employment law. So I'm not providing you legal advice, but I can give you guidance on what the law says. I can help walk you through the process, filing a charge, and all of that kind of stuff. I can tell you what kind of evidence you need in order to find a violation, but I'm not giving you actual legal advice on what it is you should and shouldn't do. So we are going to get started. Hold on, let me share my screen. Here we go. Sharing screen, sharing screen. Okay. So, can I get a quick thumbs up if y'all can see my screen? Perfect. Thank y'all so very much. Okay. So, discrimination is illegal within work. And so who is the EEOC? As I said, we were born out of the civil rights marches on Washington and all the fights that came out of the 1950s and 60s. But we are a national federal law enforcement agency. We enforce federal civil rights laws. We're going to spend a little bit of time walking through what those are. And our mission is to prevent and remedy unlawful employment discrimination and advance equal opportunity for all in the workplace. And ultimately, what is it that our agency does? We have a lot of things that we do. We're responsible for enforcing federal laws that make it illegal to discriminate against job applicants, employees, and former employees. We accept charges of discrimination. We're going to walk through what that process actually looks like today. We investigate charges of discrimination. We mediate those charges to see if we can resolve. We conciliate. So if we do indeed find possible violations of federal law, we try to resolve those. We educate. That's what I'm doing over here. And we litigate charges. So if we find violations of federal law, we litigate on behalf of the general public. So it's not just going to be the individual we're litigating on behalf of, but it's going to be the general public as a whole. So EEOC versus said company that was violating the law. and we do a lot more. We do things like we have administrative judges on hand that will look at federal violations. So things like if you have a federal employer that is violating the law. So maybe the TSA or the Department of Labor or the Department of Justice. We do things like settlement conferences. We answer things like Freedom of Information Act questions, all those different types of things. We are located throughout the entire country. As I mentioned, we're national, right? So we've got district offices. Los Angeles is one of those district offices. And then we have local offices. There's 53 of them. The Los Angeles district office here has local offices attached to it in Fresno, San Diego, Las Vegas, Honolulu. But our jurisdiction is super wide here in California. The Los Angeles office actually covers Central California all the way down to the border, all the way east to Nevada. We cover Central Nevada all the way south to the Arizona border in Nevada. And then we cover Hawaii and then all the islands out in the Pacific, such as American Samoa, Guam, the Northern Mariana Islands, and Wake Islands, any of those American territories out there in the Pacific. So those are what we have there. We are based out of DC. All or the majority of, federal government agencies are kind of based out of the Washington, DC area. And then ultimately, what is discrimination, right? We all kind of know, we feel when discrimination happens. Discrimination is to treat somebody differently, right? Less favorably, unjust, or prejudicial. Employment discrimination occurs when individuals are being treated differently or harassed because they belong to what the law terms as a protected category. And there are 9 very specific protected categories as defined by the law. And this is as defined by federal law. State law in California is broader, and they're going to have broader and more encompassing protected categories. But today we're just talking about federal law. So for federal law, we look at these 9 protected categories. We have race, color, national origin, and ethnicity, religion, sex. All of those are going to be covered under one law. And then each one of these other ones are going to be covered under different laws. Age, if you're over 40, disability, genetic information, genetic information, pregnancy. And then each one of the laws that we enforce also has a retaliation provision, which makes it illegal to retaliate against individuals if they were to file a charge or complain about discrimination or harassment in the workplace, if they participate in any type of an employment discrimination proceeding, which means maybe they're part of an employer's investigation, or maybe they're participating in an EEOC lawsuit. Maybe they actually just participated in what we call an EEO activity. Maybe they had a disability and they needed an accommodation. Or maybe they needed a day off for a religious holiday and they asked for that. Those are participating in what we would call an EEO activity. Or maybe they're associated with somebody who did any of the above. So maybe they are a family member of somebody who did any of the above. It is illegal to fire or demote or to take any other what we would consider a tangible employment action. So an actual action at work, not a they looked at me funny or they stopped talking to me sort of thing, but an actual negative, tangible employment action. Somebody did that at work. It is illegal to retaliate against that person because they participated in a what we would consider a protected activity. But I want to spend a little bit of time kind of just breaking down these laws a little bit more. So we're going to talk about each one of these laws individually. Title VII of the Civil Rights, super near and dear to my heart. It's what actually created the EEOC. So Civil Rights Act was signed into law on July 2nd, 1964 by President Lyndon Johnson, and it codified into law the creation of the EEOC. We opened our doors exactly 1 year later on July 2nd, 1965, which means we as an agency just celebrated our 60th anniversary. This law says it is illegal to discriminate against an individual because of race, color, national origin, religion, or sex. And when they get into kind of the nitty-gritty of the actual language of the law, it says you cannot hire, fire, or treat somebody differently in regards to terms and conditions of employment because of, and then you fill in the blank. And that's where it becomes really important because if an employer takes into account a person's race, the color of their skin, which is the pigmentation of the skin, so if somebody is lighter or darker than somebody else, their national origin or ethnicity, which could also include their language or accent, where they were born, where their family is from, their religion or the assumption of their religion or their sex, if they take into account that and they make an employment-based decision, then that decision is because of sex, because of religion, because of national origin. And so it's just very important to, in the plain language of that law, that anytime we have an employment-based decision and one of these somehow came into play, it is actually illegal. So that is something for us to be really thoughtful of when you're thinking about, hey, I think I've been discriminated against in the workplace, and I think it's because of my race. Did the employer take into account, my race when making an employment-based decision? And you may say, well, Nikki, how do I even tell this? Well, when we're looking at these cases, we want to say, well, did somebody else get what we were trying to get or were treated better than us? And they were of a different race, a different sex, a different national origin. And is there a reason that they were treated differently from us that could be explained outside of that? And if there is not, then we would say there could be a violation of law here. And that's what we're really doing. We're doing a comparative analysis when we are doing our investigations here. We are trying to see if all other things being equal, if the only thing left here is race, color, national origin is our difference, then that has to be the reason why. And so, or we have direct evidence, right? Sometimes we get direct evidence that the reason somebody made this decision is because they made an assumption about somebody's religion or that they had said religion, and they're then not going to hire them because of it. That was a case against EEOC versus Abercrombie and Fitch. They assumed somebody had a specific religion, so they chose not to hire them, even though the person never said they had this religion. It didn't matter. They made an assumption about a religion, therefore chose to take into account religion. Any employment decision in which religion came into play, regardless of whether or not that religion was or was not assigned to this actual person, didn't matter. It came into part of that decision is illegal. You'll see reasonable accommodation is also under Title VII of the Civil Rights Act for religion. Individuals have the right to request a reasonable accommodation for their sincerely held religious, moral, or ethical beliefs, absent undue hardship from the employer, which means if you need an accommodation for your sincerely held moral or ethical beliefs at work, it could be something like, I need to wear a specific religious garb. I need to wear a yarmulke. I need to wear a hijab. I need to carry a kippah. I need to wear a Star of David. It could be anything that you're asking to wear at work. I need to be able to wear a beard at work in order to express my religious faith. I need to have an what's the word I'm looking for? I need to be able to not take a vaccine because it goes against my religious faith. I need to have a specific day off in order to observe a religious holiday, or I need to have every Sunday off to observe my religious beliefs. Those type of things, you can request that through your employer, and your employer must show that it is a significant burden on the employer's business to have that time off, and it would be an undue hardship on them. So those are the type of things that you can request as part of a religious reasonable accommodation under Title VII of the Civil Rights Act. All right. Any questions about Title VII before I move on to, oops, I keep hitting extra buttons here. All right. Equal Pay Act. So this just says that men and women must be paid equally, compensated equally for doing a same or similar job. Compensation can be a lot of different things. So we're not just talking about wages. We're talking about if people get, gas cards or a car or benefits packages or commission structures, anything like that. Um, it is one of those laws that whereas we're going to talk at different times about how many people you need to have within the workplace, you actually only need one person to actually be in the workplace here. But it really does protect both men and women. We have had cases where it is the men who are paid less than the women. We've had cases where it is women who are paid less than men. Um, there is the Lilly Ledbetter Fair Pay Act that was signed. It was the first piece of legislation signed into law by President Barack Obama in 2009. Prior to this, the case of Lilly Ledbetter, she worked for Goodyear Tires. She worked there for 20 years, and she found out years into her employment that she was getting paid significantly less, way less than her male counterparts. And she brought an EPA case through the EEOC to court. And the problem is that the court said, "Hey, you know what? I am so very sorry, but the decision to pay you less happened on the day that you were hired, not the day you found out. So you are outside of when you can file. You have passed the time frame when you could file and go to court, which typically for most cases is like 300 days, so 10 months. She found out years and years later, which didn't seem quite fair because most people don't talk about how much they get paid. And so the Lilly Ledbetter Fair Pay Act that was signed into law by President Obama said that every single time an employer decides to issue you a paycheck, they are deciding to pay you an unfair wage or a discriminatory wage again, every single time. So, yeah, they may have decided to pay you at a different rate than your male counterpart or your female counterpart back when they hired you, but they reaffirmed that every single time they issued you a paycheck. So that started the clock over every single time they issued you a new paycheck. So this then expanded the Equal Pay Act so that every new paycheck was a new violation. And so we had like really super excited to have that. We were sad that we did lose Lilly Ledbetter this past year. She passed away. But it was one of these really great kind of groundbreaking ways to kind of expand just our ability to assist people under the Equal Pay Act. Ooh, Nicole, I have a question. What if you work under the table at an event and all the other employees were paid and I never got paid at all? So working under the table is actually a violation of the Department of Labor or the Labor Commission. So those are two different things. So that's why we actually shouldn't work under the table because it's much, much harder to track. Working under the table, like for going federally, is a Department of Labor issue, wage and hour. Here in the state of California, if you want to go there, that would be a Labor Commission question, Labor Commissioner question. Um, and you would have to work to show that it was something where everybody else was paid and that you were then not paid. Um, so yeah, so that's where you would go. Unfortunately for me, it's not something that I can cover because of the way that you're being paid under the table. So you would have to go to um, other agencies on that one. But good question. I'm glad you asked it. Thank you so much for that one. All right. Age Discrimination and Employment Act protects workers over the age of 40. It came out in 1967. President Johnson actually wanted to include it in the Civil Rights Act, but Congress at the time decided that nobody cared if people were over 40 in the workplace. He refused, but he did get it passed 3 years later. Um, The state of California actually has a, we don't care how old you are, they have an age protection. So if you're younger than 40, the state of California will protect you. But for the federal government, you have to be over 40 in the workplace. The federal government, we've actually seen a big rise in recent cases of filings against employers for age discrimination. Um, we've seen a lot where there've been like kind of forced retirements, forced reduction in forces, so RIFs and forced layoffs. We had a really large case against Jet Propulsion Laboratories that resolved for $10 million. That was where they got rid of all their older workers and then hired a number of younger workers, but they kept like one older worker. And we're like, look, we didn't do anything bad. We kept one older worker. So, it's those kind of things where employers like to kind of show you, well, we kept one, so we don't discriminate. Yeah, it doesn't really work that way when you kind of do a statistical analysis across the board. But we're seeing that. We're also seeing things where sometimes they're making these really blanket assessments that say, well, we're going to force everybody of a certain age to retire because we think that everybody, once you hit a specific age, can no longer do a job without doing very specific like analysis and testing. So we had a case not too long ago that was in the news that was physicians with scripts who were being forced to retire because they'd hit a certain age, even though they had no problem whatsoever doing their jobs. There was no complaints against them, but the company just decided that everybody had to retire by a certain age, regardless of whether or not they could still do the job. And so we've had cases like that where they've had kind of forced retirements, and we've had to resolve those types of cases as well. Americans with Disabilities Act, it is the second most common case filed with our agency nationally and in the state of California. So the Americans with Disabilities Act, for those of you who don't know, 80% of us is going to develop some form of a disability within our lifetime. And we may or may not need assistance through the ADA at our workplace. It is something that is really near and dear to my heart, not just because my second language in life is American Sign Language, and I was hired with the EEOC as an ASL bilingual investigator, um, but because it just astonishes me that this came out in 1990, so it's only 35 years old. And if you think about the fact that it's only been 35 years since we have allowed individuals with disabilities to say you have the right to go to the restaurants with people, you have the right to go to a movie theater. Like if you had a disability, you didn't have the right to enter a bathroom in a public facility. Like it's just crazy to me that 35 years ago, people didn't have the right to have communication across the United States if you had a disability. Like we have really come so far. But the Americans with Disabilities Act prohibits employment discriminations against qualified individuals with a disability, which is a physical or mental impairment that substantially limits one or more major life activities. And we really look at this very, very broadly. So the idea here is that this came out in 1990. The courts really spent a bunch of time narrowing down what physical mental impairments were that substantially limit a major life activity. And in 2008, Congress said, whoa, 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 courts, too much. This is not what we meant. We really wanted you to look at this as broadly as possible because our goal under the ADA here was that y'all were going to actually accommodate people in the workplace, not make this harder. So they did an Amendments Act in 2008. And so I just really want to like put it there that like this reads a certain way, but the entire idea that employers are supposed to do is they're supposed to accommodate. You can have a record of such an impairment. So think if you had something such as um, cancer, it's in remission. You just have to go every, 2 years to get scans to make sure you don't need to worry about it anymore. I think we have somebody drawing on the PowerPoint. Um, or then also just having a record of such an impairment. And then qualified means, I think Delora Ellis is drawing on the PowerPoint. Um,
Or can you, I don't know how you would stop drawing on the PowerPoint, but
I
hold
don't
on.
know.
Yeah, hold on. Let me try to
No
figure this
problem.
out. Okay.
And then qualified just means you have the ability to do the job, right? You got the requisite skills, education, experiences, and you can perform the essential functions of the job with or without a reasonable accommodation. And then it requires employers to provide reasonable accommodations. It provides guidance about disability related exams. And it also tells you that you can't mix up um, medical information and all records have to be kept confidential. This is another area where sometimes it's a little bit difficult for employers. Like you can't, if somebody has doctor's notes or they're asking for accommodations and things like that, sometimes they put that information into personnel documents or a personnel file, and you cannot do that. You can't keep them in the same file. And so we want to make sure that all of those would be kept separate. But it's really important to know that the ADA is there for everybody to be able to have an opportunity to ask for an accommodation. Accommodations can look like everything from, hey, I need a day off to go to doctor's appointments, or I need to take leave to have surgery and recover from surgery, to I need to telework for a period of time if my job can and does allow telework, to I need to have a standing desk at different times. I need to have a specific chair. I need to have the ability to go to the bathroom whenever I need to go to the bathroom. Very simple things it can be. I need to be able to have a bottle of water at work. I need to be able to, sit down when I need to, stand up. I need to have a stool, whatever it is. There's like some very interesting things that sometimes employers don't allow you to have that you would think would be very simple and easy accommodations, but sometimes employers kind of dig their heels in. We've had a number of cases in which it is a stool that an employer will not allow a person to have because they firmly believe a hotel receptionist that standing is an essential function when a hotel receptionist greeting people and talking to people and being kind is, that's kind of more the actual essential function, not standing. Standing is not necessarily an essential function, and sitting down can be accommodated. So, those are the types of things that sometimes we run into with employers. Genetic Information Non-Discrimination Act. I always joke that this is one of those times where Congress was actually thinking forward. This came out in 2008. I'm pretty sure if you kind of asked anybody in Congress what any of this actually means, they wouldn't even know what genetic information is, let alone how we were going to define it in the land of discrimination. But it basically means that it is illegal for an employer to, in any way that they were able to get this information, obtain your genetic information. So, did they find out that you carry the breast cancer gene? Did they find out that you have family members that had a heart attack? So maybe you now have heart disease. Did they find out that you are really interested in doing an epilepsy walkathon because you have a sibling that has epilepsy? Anything like that is genetic information. Did they find out that your spouse has? Like, I didn't even really quite get in the beginning the genetic information of your spouse counts. Um, it is illegal for your employer to take any information that is genetic in nature of your immediate families, your grandparents, your brothers, sister, your parents, your child, and your spouse, and use that information, whether it can be from social media posts, from you just talking about things at work, to cases such as like 23andMe. We had a situation where somebody found out that through genetic testing, like a 23andMe, that they had um, African, they were part African and they hadn't known that beforehand. Then they started getting racially harassed at work because of their African ancestry. So we filed a case against the employer for racial harassment and genetic information um, against them. And we won the case in that. So we were able to do it through genetic information. It didn't have to be genetic medical information, but we had genetic information and racial harassment in that case. Carla, I saw your hand pop up really quick.
We have two questions. One was in the chat,
Oh,
and then Carla had a question.
oh, okay.
So
Let me go see the chat question.
mhm.
Could long COVID be considered a disability? Michelle, there's that the it's still out. So I was gonna say the jury is still out on long COVID being considered a disability, but I will say that you can probably break down the individual aspects that is affecting you from long COVID and have those individual aspects be considered a disability. And I say that because long COVID has things like ongoing respiratory issues, memory issues, heart palpitation. So, see how I broke that down? So, it's things like obesity is not necessarily considered a disability, but obesity leads to and has other comorbidity issues. So, oftentimes, people who are obese may also have diabetes, heart conditions, all these other things. So, even if you don't have it one way, you can be considered having a disability a different way. With long COVID, some of the medical, you may have some issues with some medical personnel recognizing that long COVID is or is not a disability. My recommendation to employers all the time is that you are not a doctor, so you should never be questioning a diagnosis, period, that a medical professional makes. If they say this is a disability and you need X, then that's it. None of us have MDs after our names. However, if there's a way to break down the diagnosis into whatever else there is, it might just be easier in the long run because long COVID is still being worked on through the medical field, if that makes any sense. So, and then Carla, you raised your hand as well.
Yes, I was gonna ask about the genetic information, if that includes like ethnic background or ethnic group, but then you answered it for
Yeah, it
me.
can.
Yeah, because
Absolutely.
I was wondering, because all the like ancestry.com and the DNA testing for ethnic background is really popular nowadays. I
Hmm.
didn't know that the other side of it was like if you have the genetic marker of an illness. So I didn't know that. I thought it was just like ethnic DNA, ethnic background.
So we started when we started seeing Gina cases, we only started seeing them as like medical because it that's how we saw them come in. It's just been more recent that people have been educated about Gina, like because if you don't know the law exists, you don't know that you could come in and file. That we've started seeing more of the 23andMe type cases come in. And then also there's a lot in the news recently where like 23andMe was getting sold or going bankrupt, and then all that information was going to be out there, and people were getting scared that once your employer gets your information, however that is, or your information is just out there, who has access to it and how can they get it, right? I mean, those are the type of things that are always just kind of scary. Who gets it? Is it accurate? What are they going to do with it? Um, so that's why it's like whatever's on the internet is always scary as well, you know? So, but yeah, same type of thing. Thank you so much for raising it. Okay. Pregnant Workers Fairness Act, it's our newest law. So it was signed into law in December of 2022 by President Biden. We just started taking charges in June of 2023. We've only had a handful of these cases go through the court, um, in the sense of like winning. There's a lot of cases in these in court right now for injunctions and people arguing them and things like that, which is what typically happens when you get a new piece of legislation. Um, but the Pregnant Workers Fairness Act requires covered entities, like so employers that are covered under the law, to provide reasonable accommodations to qualified employees or applicants with a known limitation related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, absent undue hardship. All the language here is pulled directly either from Title VII's definition of pregnancy that was adopted by the Pregnancy Discrimination Act and pulled into Title VII, or the Americans with Disabilities Act. So when Congress put this together, they said, hey, we're not going to make this difficult for people. We're just going to combine two laws into one. So these provisions are super similar to what's required under the Americans with Disabilities Act. Before this law passed, there was no federal law that protected pregnant workers that needed an accommodation in the workplace. So if you're pregnant and you need to go to the bathroom more often, and hey, in the state of California, we had laws. But maybe in some other states, there weren't laws that protected individuals that could go to the bathroom because they had a 9-pound baby sitting on their bladder and they were trying to work really hard right up until the last moment. Or we have FMLA, right? And FMLA sounds super great. You get 12 weeks of protected leave. That's only if you've worked there for 12 months or 1,250 hours, and that's only if the employer employs 50 employees, and that's only if they all work within a certain mile radius. The Pregnant Worker Fairness Act says we don't care about that. You have to have 15 or more employees. We do not care how long you've been working there. You could have been working there for the past 6 months. You could have been working there for the past 6 weeks. You have the right to go on maternity leave and have protected leave as a reasonable accommodation. You have the right to go to a doctor's appointment to maintain the health of yourself and your pregnancy for a normal pregnancy. You have the right to have an accommodation and to have even an essential function of your job be suspended for the time of your pregnancy, as long as you can do it once you get back to work. So this is a huge step for individuals who are affected by pregnancy. Like, this is something where for most of us, it would just appear to be common sense, but in many places that have workplaces that are just like, you know what? You don't get to just go to the bathroom. You don't get to, once again, just have a bottle of water with you, even though it's required. You don't get to just go to the doctor. Or you have to, once you've used your leave, now you're up for termination. So it's just another way to have that protection that we didn't have beforehand. Then we also have
Oh,
harassment. So, oh, go ahead. Yeah.
there's a question in the
Oh, thank you. This is
chat.
why I need you, Tara. All right. Wondering if all the cuts at the federal, Michelle, you getting to me. Wondering if all the cuts at the federal level will have a delayed impact on EOC complaints being taken and resolved here in California. Well, Michelle, can we get to that part? Let us get to how we're going to talk about filing. And I promise I will talk to you about where we're at with all of that. And we'll talk about where we're at with just, the EOC in general and everything else. So hold your question, Michelle. I got you. It's coming. All right. Talk briefly about harassment. It's unwelcome comments or conduct based on a protected basis. That one's kind of hard at times. We often know that harassment is something that we feel in the workplace, that we know is happening. For federal harassment and even for state harassment, this is the same here. Oftentimes we can find bullying, we can find disrespectful behavior, we can even find abusive behavior. But when we're talking illegal harassment, it has to be based on a protected category, both at the state level and the federal level. Unwelcome comments or conduct based on your race, your sex, your age, genetic information, disability. Go down my little list there. The object of the harassment can be anyone or a witness to the unwelcome comments or conduct. I do not have to be the person that is being harassed. I can just see it happening. I don't have to be a member of the protected class that is being harassed. Just being a witness to it happening means I am now a victim of that harassment. The alleged harasser can be someone of the same or different protected basis as the person who's being harassed. And the harassment can be done by a supervisor, a coworker, a non-employee, or a third party. So it can be your supervisor or your coworker. It could be a non-employee. So it could be somebody like, think about the mail person who may come in and out of your workplace or the water delivery person. It could be your customer, right? It could be the people that are dining in the restaurant. It could be the people in the hospital that you were providing services to. If you are a nurse or a doctor or an orderly, it could be the individuals that are in the prison. Like it could be those individuals. It could be a third party. So it could be somebody that you are working with that you're assigned to. So maybe it is somebody that you're working alongside, you're assigned there to do work, but they're not your employer. So it could be a third party. What matters is that there is control by your employer over whether or not you have to be in that situation. Right? And so that's the important part there. Does your employer have control over whether or not you have to be in this situation? And welcome means that the individual did not solicit or invite the conduct, and the individual regarded it as undesirable. What if you had a conversation with a supervisor that was interpreted as a threat? Kenneth, that the supervisor interpreted as a threat? Think I need a little bit more background. Do you mind taking yourself off mute and chatting?
Sorry, yeah. So this is something that I experienced. So I had at my previous job, I had a conversation with my employer. Um, and when we were having the conversation, a lot of it was kind of, I guess he was not happy with my performance and he was disappointed because specifically because I was black. And he said certain things in that conversation that I felt were a threat that made me feel a certain way about the position and what would happen to me if I left my job at the time. But it was never written down, or it was never like there were no email exchanges or anything. It was just a conversation that we had. Would that be something on the grounds to would that fall within the conversation that we're having now?
So it would depend. So my first question to you would be when he said things that were based upon your race, were they things that could be tied back to your race, such as things like racial epithets? Were they things that were specifically targeted, like about your race, your looks? Did he say things that were more were kinder to individuals that were not of your race compared to you?
It
How
was
did you know it was about your race?
it was more I expected more of you, or I expected you to do this because you were black, or I expected you to be this thing that other employees were specifically because you were black and they're not black.
And he said those words.
Yes.
Okay. So, yes, I mean, I would consider that something where I'm not necessarily sure it would be harassment. More, I would consider it like you would be like a term. So you were not promoted or you were not like this to me would be like this would be why you didn't receive a promotion. This would be why you had different terms and conditions. This is why you were given different job. I wouldn't necessarily say this would be harassment per se, but more along the lines of why you may have been treated differently in work. Like you should have done something differently because you were black. I expected more of you because you're black. So it sounds like he had a higher standard of you because of that. So though it's not written down, and though it was just a one-on-one conversation, that doesn't mean we can't go forward. It makes it harder, right? Because it's a he said, because you're your other supervisor. So this is just like we're gonna have a discussion on how to like go forward with an investigation in this sense. Like it's a he said, you're saying one thing, your supervisor will deny it, right? 9 times out of 10, your supervisor would deny it. For our agency, we would first say, okay, well, let's see who we feel is kind of just a little bit more honest in these situations. And then let's start digging into who else has this man supervised. And we're going to start talking to all those people, right? Were you the only Black person he's ever supervised? If not, well, we're going to talk to every single one of those Black individuals he's supervised, right? Because if he said it to you, he's going to have said it to somebody else as well. And then this is going to start showing that what he has said to our investigators and denied saying anything is not truthful. So now we're doing an assessment on what he says, right? So it's called a credibility assessment. And this is how, under us being a civil law enforcement agency, we start looking at what's called a preponderance of evidence, or discrimination more likely than not occurred. So the information you're giving me, though may have felt harassing, does not fall under how we would look at harassment, but it does fall under more on what we would look at if you were being treated differently in the workplace. So something more like you had different terms and conditions at work, you were given different assignments, you were not given a promotion, something like that. It's not going to rise to the level of harassment, because for harassment, we're looking for severe or pervasive treatment. That's not the type of unwelcome comments or conduct we're seeing here. But you do give me other information here that could have been something. Does
Um,
that make sense?
Also, I just wanted some more context as to how that would work, especially since there's no paper trail. I do have
Mhm.
other conversations that relate to different different conversations that we had, but specifically as far as like discrimination or harassment, that was
Mhm.
the main thing that stood out to me. So I just wanted some
Oh, yeah,
clarity.
absolutely. And then also for anybody, anytime there's conversations that happen that you are like a one-on-one, because they happen all the time, and you're just like, so good with this conversation, but it was a one-on-one. So how can I document a one-on-one conversation? Follow it up with an email, right? Just sit there and, hey, so and so, thank you so much for meeting with me. I just want to make sure that I completely understand everything we just had a conversation about. I just want to make sure that I understand that you feel that I should have done more because I am Black, that you expected more out of me because I am Black. That is what I took away from the conversation we just had. Like, and I would just spell it out and send it. And then they have an opportunity to rebut it or not. And that's kind of one of those things that you do anytime. I tell supervisors to do this, and I tell employees to do this. If you have a one-on-one verbal conversation, follow it up with an email. Send them an email and say, just want to make sure that I understand the conversation that we just had. I took away from it this. Please let me know if there's anything you would like to add, or something like that, just so that it is in writing. And then that way you have a written documentation of your conversation. So, alrighty. I hope that helps. Always have written documentations. All right, examples of harassment, just so we have just a couple of ideas. And remember, I said harassment needs to be severe or pervasive. Severity, the use of the N word one time, the courts have said counts as severe. Pervasiveness means it's happening kind of over and over again. So it depends on what it is, on whether or not the courts are going to say severe works or pervasiveness. Hanging a noose at work, depending on the jurisdiction, could be severe, could be pervasive. So sucks to say, if you're in the South, they're going to want that to be happening more than once. If you're in the state of California, one time, severe. Emailing coworkers derogatory cartoons about ethnicity, constantly asking older workers when they're going to retire, making fun of a person's accent, physically removing a person's hijab just happened out of the state of Tennessee to a young worker at Chipotle. Frequent remarks about a woman's place being in the home, conveying stereotypes about employees with disabilities, constantly yelling or intimidating behavior towards an employee that's complained about illegal discrimination. And then just a chat about what's not covered, simple teasing, not based on protected bases, offhand comments, a one-time comment or a minor incident. Anything that is small isn't going to be covered. Once again, for a violation of federal law, it does have to be either severe or pervasive for the conduct to be there, or there has to be by a supervisor what we would call a tangible employment action, which means a supervisor has to have either done something, so has promoted you, like given you a benefit because you went along with the harassment, or took something away from you because you rejected the harassment. So if you went along with sexual harassment, they promoted you. If you rejected sexual harassment, they demoted you. Carla, your hand's raised.
Um, I have a question about the offhand
Mhm.
comment. What would be an example?
Of an
Maybe.
offhanded comment.
Yeah.
Um, I really like the way your hair looks today. I know that sounds silly, but you would be surprised the number of times I've had people come in and complain about harassment because someone commented on somebody's hair.
Okay.
I will also say things about like I don't like my supervisor, or I don't like being told how I'm supposed to dress at work. I had one time somebody came in and complained about harassment because their supervisor kept telling them they dressed too provocatively and were commenting on their underwear. And I was like, well, because I can see your underwear through your clothes, I think I understand why your supervisor is commenting on your underwear and saying it's not appropriate in the workplace. So I understand that. I don't feel that that's sexual harassment. I feel like I was trying to tell you you can't wear see-through clothing so that we can see your underwear. Um, I've also had people come in and say things like, you look really nice today. And a comment like, hey, you look really nice today is what could be considered as an offhand comment.
Okay.
Um, and that's not necessarily a harassing comment. Or, we just talked about something like, hey, when are you going to retire? Or, hey, you just celebrated 35 years with the agency. That's amazing. Do you think about retirement? Someone may take that as negative, but that is just an offhand comment that kind of anybody would say, right? I'm just thinking right now, thinking that I have my kids over here. My kids one's a COVID baby and was two during COVID. The number of comments I got about my choice to put my children in daycare during COVID and
Mm-hmm.
how I should have stayed home instead of working during COVID.
Mm-hmm.
Those are kind of those offhand comments that probably everybody felt very like, oh, we're just being kind to you.
Mm-hmm.
I feel like I hear them at the door. They were, so those are kind of these offhand, minor, isolated incidents or comments that could be
I
there.
have a question. It's kind of a little specific. So what if there's like a hiring freeze, or the company just takes a long time hiring people? So what if the supervisor says something like what if an employee says, well, when will the hiring freeze be over? And then the supervisor says, oh, we can't hire anybody, but if I could, I would hire such and such. And so
Mhm.
what if that person is like a different race than the employee who's asking?
So there's nothing that time until the hire. So that could be used if once the hiring freeze is over, and then that person that was selected is
Okay.
that person, and then you could somehow show that that person was less qualified than other people of a different race. Like
Okay.
that they had that person in mind, they weren't
Mhm.
qualified, so they already had this kind of thing planned out,
Okay.
that's where they were going. But we have to wait until the negative employment action happens, which means the hiring freeze has to be over. Otherwise, there's no vacant position. So we have to wait for that to actually happen first. So, cool. All right.
We
Tara, I'm
have
not
an
missing
awesome.
anything in the chat, right?
No, there's somebody on just by the name of iPhone has their hand raised.
Oh, iPhone.
That's probably me, Tara. Nikki, I'm so glad you're here tonight. I mean, these discussions are just so critical for Black workers. My question is more general. It has nothing to do with any specific case. It has more to do with the lifeblood of EEOC, given that the current administration has called for major cuts in your funding. My question is, how do you see an opportunity for EEOC to continue to support workers in the future?
Whew. So can I answer your question when the same time I answer Michelle's question? When I get a little bit further down?
Sure, sure, no problem.
No problem. And the answer is still yes. Like, feel good about that. The answer is yes. I'll talk about the cuts and kind of where we are, especially once we get into like talking about how you file a charge, because there's always a question about how long do we have to wait for things. And I have no problem talking about kind of where we are because we have a new administration and things change. But let me get through just this part and then let's have a little quick discussion about kind of the life's blood of the EOC as I am a longtime EOC lifer here. So all right, let me move really quick to hostile work environment. Once again, we kind of already talked a little bit about the offended individual does not need to be the target of the harassment. We just have to be affected by that conduct. And I really want to sit there and say the harassing conduct can happen outside of work, and it does give rise to liability with connections to work. And on here it talks about a business trip or a business party, but I really want to let you know that there's a recent case just last year that came out of the state of California. The case actually happened in Lompoc Prison. So really right here in Southern California. Called Okanowski versus Garland. It is going to be my new favorite, super nerdy case, but it's about social media. So it was heard through the Ninth Circuit Court. And it really talked about the totality of circumstances under a sexual harassment case because under the circuit court here locally, the district court, they said that, well, on this case, that there's a social media case, they really only counted like 3 social media posts in this entire sexual harassment case because only 3 of them happened or were posted inside of the prison even though there were hundreds and hundreds of posts affecting this prison psychologist that was being she was being targeted she was being targeted by the guards, she was targeted by the HR department, the safety officer, the person who was supposed to be investigating her sexual harassment complaint was a part of it. Everybody was liking it. Everyone told her to get over it. The warden told her to get over it. I mean, it was just absolutely horrific. The Ninth Circuit said that the images and the posts were so bad they couldn't even include them in their opinion because of how horrific it was. But basically, there was a lot of stuff about gang raping her and everything else. And these were from the prison guards who were supposed to be protecting her. But they basically said you can't just take it out of context, that everything within it actually had an impact on the workplace. So it's a really great case to show that social media in and of itself, because it lives forever and it doesn't matter whether or not it's happening and you're posting inside of the workplace or outside of it, it can have a direct impact on what's happening in the workplace. So it's a really great case to show how pervasive social media can be. A couple things about coverage, which I think are really important for us to know, is that our laws protect employees and applicants for employment, former employees, temporary workers, people who are working in staffing agencies. We've had some recent cases. We had a recent case last year against Barron HR and Radiant Laundry Services here in Gardena. Barron HR was a national case. They were the staffing agency. Radiant Laundry Services here in Gardena was who Barron HR was providing the services to. It was a case that had everything from Title VII. We didn't want to hire anybody that wasn't Hispanic or spoke Spanish. We only put men in the heavy lifting jobs and women in the folding laundry jobs. We didn't want anybody with a disability or had a record of a disability or even looked like they may have a disability. We didn't want anybody who was older. It covered absolutely everybody. So it was staffing agency, temp workers, absolutely all of that. So all of that's covered. We cover applicants, participants in training and apprenticeship programs. So if individuals are trying to get into things like construction work, any of the different types of unions, things like working like the Longshoremen Union, unions down on the docks in Long Beach and things like that, and you need to get into the union before you can even get assigned to the different jobs. We cover those types of things as well. We don't cover independent contractors, but if you have cases where you think you're being assigned as an independent contractor, but the majority of the work is being controlled by the employer, it's incredibly important for you to come and talk to us anyways and let us have the opportunity to take a look at that because oftentimes employers will try to say that they're an independent contractor when ultimately they are having all the control and power and they're just trying to do it to get over on having to follow the laws in that sense. EOC charges can be filed against your regular companies like Lowe's, Walmart's, McDonald's, things like that. They just have to have 15 or more employees. Oftentimes, even if you have like a McDonald's that looks like it only has 12 employees, they may be part of a franchise. So we look at the whole franchise. Private sector companies, so they have 20 or more employees if they're underage. State and local governments. So that's like, your LAUSD, your UCLAs, all of those kind of things, your LA County governments, your state of California, Lompoc, which I just mentioned, employment agencies like Barron HR or any of those other staffing agencies, unions, your training programs, applicants, and things like that. For timeliness, you have to file almost every one of under all of our charges within about 10 months with us. So 300 days from the date of harm. If you were discharged, 300 days. If you were harassed, 300 days from the harassment. If it's something that's ongoing, then come to us as soon as possible and we're going to get everything back in that we can. If you weren't hired, 300 days from the date of not being hired. If you were denied an accommodation, 300 days from the denial of accommodation. If you were denied unemployment benefits, 300 days from the date you were discharged, not 300 days from the date you were denied unemployment benefits. Like, that's the important part. You have to go through the EEOC in order to go to court. It's called an administrative action. You have to go to the EEOC if you want to go to federal court to file an civil action. So if you want to go file a lawsuit, you got to go to the EEOC if you want to file under federal law. The only law that is different is the Equal Pay Act. That you have 2 years no matter what to go to court unless it is a willful violation in which you can prove they were purposefully paying one sex different than another. Then you have 3 years and you don't have to go to the EOC for that one. You can just go directly to court if you want to. Oftentimes, even if you have a lawyer involved, they always want you to go through the EOC first, just because the EOC, free of charge, we'll talk about that in a second, but then the lawyer can ask for all of the information through freedom of information. They can get all the work that we did, and they don't have to do as much work, but they can still charge you. As I said, you have to 15 or more employees, 20 or more for the Age Act, only one for equal pay because you would compare yourself to the person who had the job beforehand. Under the California Civil Rights Department, you can have less employees. So if for some reason you call me up and you say, hey, Nikki, I don't think I've been hired by this employer. They only have 10 employees. I'd be like, hey, look, I am so sorry. I can't help you with this one, but I'm going to refer you to the California Civil Rights Department because they can help you. Right. And so that's the one thing that you're always going to get when you talk to me is if I cannot help you, I'm going to refer you someplace else. Like I'm going to refer you to the labor commissioner, or I'm going to refer you to the California Civil Rights Department. If nothing else, I can get you to the right spot. Different people can file charges. The majority of our charges are individual center charges. So the aggrieved person files the charge. So I'm the one that wasn't hired, I'm the one that files the charge. Sometimes individuals or organizations will bring charges on behalf of others. The largest human trafficking case that my agency has ever done was for 500 Thai workers out of Los Angeles that were trafficked all over the country, was brought to us through a organization called the Thai Community Development Center, third party charge. So we do have those type of cases that come in. Sometimes you'll have a parent of a young teenager who's got their first time job and they're being harassed or discriminated against at work, and they would file on behalf. Um, we as an agency can also file on cases. So we currently have a case right now in litigation. It's called a directed charge. We have EEOC versus Meathead Movers. It is an age case. It's ADEA case. It's a moving company that didn't hire anybody under the age of 40 for any position, whether it was moving, packing, customer service, didn't matter. They didn't hire anybody under 40. So we can file direct charges, or our commissioners can file direct charges under Title VII, ADA, GINA, or PWFI. So if we get information, so maybe you have somebody who isn't comfortable coming forward to file, but you have enough information. You say, hey, Nikki, I got information. I think I got a case here, but they're not comfortable coming forward. Can I share this information with you? We can take that information and we can bring it forward. Activision was this huge case in which there was like sexual harassment and pregnancy discrimination. CRD did it, we did it, like everybody did it. But that came as an anonymous complaint. We never had a body. So we did a commissioner's charge. CRD did their own directed charge. We had one of those type of things through with Activision. Let's see. We cover everything and every type of decision that can happen within the workplace. So everything from the start, how you advertise and recruit, to hiring, to reasonable accommodations during the hiring process. If you have a learning disability and you're dyslexic and you need more time in order to fill out an application, or you need a specific type of reader because you can't read the application because you're dyslexic, or it's a time test and you need more time to fill that out, that's an accommodation during the application process. Firing and layoff, we talked about wages, segregated use of company facilities, or even how you would be assigned different routes and things like that. Leave, harassment, promotions, job testing, anything and everything. If it can happen within the workplace, it's something that we're going to look at and cover. And then this is where we talk about filing our charges. So we are back open in person here in LA. You can come in. But even if you come in, this is what we're going to tell you to do. So step one, you file online. And Tara, I'm going to make a copy of this in PDF format and I'm going to send it to you so you can send it out to everyone so you'll have a copy of this. So basically what happens is you're going to go to our website and you're going to go to our public portal and you're going to answer a nice fun questionnaire that says, hey y'all, how are we going to do this? And you're going to answer some questions about, oop, there's a button in the chat. Am I missing you?
That was me saying
Oh,
thank you.
okay. Sorry. I was like, oh no, questions I'm gonna miss. We're gonna ask you questions about what happened and when was it, right? And so this just kind of gives you a little bit of information about what it looks like. And then it's going to ask you to like sign in. You know, it's going to give you an email and a password so you can register. And then it's going to schedule you for an appointment. And you're going to get a chance to look at when you can have an appointment. Um, you can choose whether or not you want the appointment to be in person. You can choose if you want the appointment to be by phone, and you can choose if you want the appointment to be by video. Those are all your choices now. Um, we are far out. Like when we talk about, hey, what's it looking like with people? What's it looking like with staffing and all of that? Nationally speaking, on average, we are 4 months out for appointments. And we do everything we can to speed that along. Like if you are really close to your what we call statute of limitations. So you're really close to your day 300, we're going to send you, you know, a charge really quickly just so we can protect your rights. Like we're not going to let that expire just because we've got this appointment thing. The other thing that we're going to do, which is kind of the Tara and I know each other, you and I are all having this conversation today, is that you guys will have my email address. So if you have things and you want to file a charge and you go through scheduling your appointment, you're going to email me after you've done that. And you're going to say, hey, Nikki, this is my charge number. I've scheduled an appointment. Let me know if there's anything sooner. And I'm going to work my magic and contact my head of appointment scheduling and say, next cancellation, my partners at the LA Black Workers Center get a little bump up to the top of the line. And that's because of the partnership that I have with Tara and the LA Black Workers Center. That's because Tara and I have been working together for years, and this is part of this ongoing partnership that we have, is that I get the extra bump with my supervisors that do this type of work. So yes, there's a long wait, but you guys know me. So you kind of get the extra like bump to the front of the line, which is nice. And that's to say that we have lost, and it's not really losing. Like we always lose people because we've got attrition and retirements and things like that. But, you know, we've gone down quite a bit. We've always been a small agency, but we've definitely hit a little bit. I think we've lost about 700 people in 2 years. So if that goes to tell you, we're down about to 1,700. And so it's a small national agency across the board. James, you got the hand up. Oh, you're on mute.
Yes, excuse me. Thank you. Yes, my name is James Johnson, and I will listen to what you were sharing about the EEOC in regards to the type of charges that we can file under retaliation or sexual harassment or unlawful termination. And then I didn't want to make it about me per se, but when you mentioned about the 4 months, you were right on key. When I filed back in 7/18 of 24, I was called down to the federal building on Temple, and I received a charge of discrimination toward my employer. So I want to ask you, being that I have saying not even me, if someone has documentation and you have the doctor progress notes, and you have been waiting since 11/19/24. I contacted Washington, D.C. I spoken with Miss Laura. I spoke to my investigator name is Miss Doreen Fisher. And you guys are back by like 2 years in looking at cases. Because when I called Washington, D.C., they contacted L.A. branch. This was last week. And she basically was saying what you were saying, that you guys, with the new administration, you're a little bit back behind, like 2 years. So she gave me an option that by October, that she would see if she could have Ms. Doreen Fisher, being that I have merit and I have documentation, and it's been a whole year since my unlawful termination and retaliation, along with sexual harassment, I might add. You guys normally take a year to resolve one of these cases with all that type of documentation on hand.
So, James, I'm going to drop my email in the chat. Can you email me your charge number?
Oh,
So,
I can give it to you right now.
well, yeah, but I can't get all the
No, no,
information
no. Oh, okay,
so
I know.
deep
I'll
for
put
it
it.
right now. I'm in the middle of a presentation.
Okay. My bad.
James,
I apologize.
James,
No,
I
no.
will pass
So,
your
Anxious.
information along to Nikki. I will
yeah.
send it to,
So
but
the
Thank
maybe
you.
make an email
Yeah,
Yes.
introduction.
I love
Yeah.
that idea. Thank
Okay.
you.
Okay.
But
Thank you.
I just say
That's even better,
because
Nikki.
Yeah,
Sorry.
oh, that's
for sure.
great.
I
And I
got
say that
you.
because A, I don't know your case, but B, it can. So I'm not going to lie and say that no, it can't, because we have some cases that can take a long time. I ain't gonna lie. Some cases can take a long time because depending on what it is, it can take a lot. Sometimes it may be very, very fast. It just depends. And then it depends on the number of people we have and the number of cases. So on average, nationally, we get 100,000 cases filed a year. And those are the charges, not just the inquiries. Inquiries are cases that get to us that we have to interview, we have to talk to everybody, but they decide ultimately not to file. Those are probably another 100,000 on top. So those are all the people we talk to. And I just mentioned we have 1,700 people working at our agency. And that counts everybody from investigators to attorneys to administrative judges to clerical staff. Like we small. We small. DOJ's 800,000 people. So we have babies. So I just say that like, yes, we take a long time, and I apologize for how long it's taken, and I can hear your frustration. Tara, if you wouldn't mind sending me an introduction, I would love that so that I can look into it for you. And I can see if there's anything that I can like at least connect a little bit more information for you to see what can happen. You're so very welcome.
I will
You
for
are so
sure
very
do that for you, James. I got mad love for you. I will make sure I do that first thing in the morning, okay?
Wait, you're muted again, James. Hold
You're
on.
muted.
Unmute yourself.
It's been an honor to listen and learn. And I'm thinking all the points that you were hitting on, I have experienced that, but I didn't want to make it about me. I want to make it about, is this the type of manner that our American citizens have to encounter in corporate America when they're in the workplace? I see if I had broke a rule, or I got a dirty drug test. I was the perfect employee for Republic Services, and they hung monkeys in the locker room, man. All this is documented, stuffed monkeys. They hung and they called me mayate and niggers, and I have documented all this. And there's not a trace of lies. So I've been asking the EEOC, when are you going to actually look into it and give me some closure, whether you go this way or that way? And this is the second time I filed on this company. And the first time they said I was out of the 300 days. But since then, Team 396 has stood by and breached a contract and allowed me to get unlawfully terminated due to my disability, my race, my age. So not about me, but I'm just saying I hope that the EEOC investigate it soon so that other African Americans at this same location don't have to continue encounter what I encountered personally. Now I mute myself again.
Thank you for sharing so much, James. I am so sorry you went through that. That is definitely one of those things that, once again, these are examples of harassment that are occurring in the work sites that is not what should be occurring,
And
period.
wage theft. So let's get the information to you, and whatever that you can do legally and rightfully, please do it, not just for me, but if
And
my
for other
daughter
people.
or son had to work at this place and encounter the names that I was called, it is un-American, unethical, and very unprofessional. And a company should not be treating anyone with melanin in their skin in the capacity that I was treated. And I have documentation. I'm not crying saying, oh, poor little me. I never came in late, never broke one rule, man, other than work my behind off for this company that doesn't respect African Americans, or they have a poor way of treating their employees. Not just me, but others as well. So let's see what Dorena Fisher can actually do. And hopefully, after I give my information to our leader, Miss Tara, we'll see what you can do. Okay?
Great. Thank you.
Thank you.
All right. Um, okay, so as we said, like my information is going to get out there. Tara's going to share my information. You're going to get a copy of all of this information. I want you to feel comfortable reaching out to me. Tara's going to reach out to me as well. And this isn't just for James, this is for all of you. I am your cut the line person. So I want you to understand that there is a wait to get an appointment to just talk to somebody. I am your person to talk to before you have to talk to somebody. So we can talk about, hey, is this something kind of like what we've been talking about right now, right? So, hey, was this something? Was this not something? We just had a couple of these conversations. That's something easy that we can do. Once again, I'm not giving you legal advice, but I'm giving you guidance about what the law says and what the requirements are and how we would look at investigating cases. To talk a little bit about what happens after a charge is filed. So the EEOC takes a complaint. We have an opportunity to mediate charges, right? Mediation is offered to everybody who comes through the door for the most part, right? But mediation is a completely voluntary process. You have to decide whether or not you want to mediate along with the company. If the company doesn't want to or you don't want to, it just doesn't happen, but it is something that we offer. It's free of charge. If that does not happen, then we look at investigating the claim. We try to find evidence to see whether or not there is a violation of federal law. And so even though discrimination is something that we know happens and we can feel it, we can walk into a room at times and feel discrimination, prejudice, bigotry. We know it when we are there, but we need evidence to support that when we are looking for a violation of federal law. We do that through direct evidence. Sometimes I have seen things like, James just gave us some information about what he's seeing in the workplace. I have seen things that absolutely say we only hire Koreans. I have the Meathead Movers case that says we hire student athletes. So that kind of leans towards why we're not hiring older workers. And so, we have that type of stuff. So we're looking for evidence. We have the ability to subpoena individuals. We interview witnesses. We can get documentation. We can subpoena documentation. We can go on site, interview people, all of that type of stuff. And then ultimately, we make a finding of whether or not there is a violation. Throughout this whole process, we are neutral. We are not siding with one party or the other. When we make a finding, we can decide whether or not there is sufficient evidence or not. If there is insufficient evidence, we are never going to say that discrimination did not occur. We are going to say that we did not find the evidence at this time to support a violation. And we're going to give you a right to sue, which gives you the opportunity to file a private lawsuit in court. Now, we could find a violation. If we find a violation, we're going to attempt to resolve that and try to conciliate it. Conciliation is a very structured settlement, and that could be something where maybe you or your attorney decide, you know what, we don't want to do it. We want to go to a private lawsuit. Or maybe, you know what, try to litigate it, right? Maybe we can't really conciliate. Maybe nobody wants to do it. Maybe it's something where we get really close and it didn't work. So maybe you end up just getting a right to sue. And so you get a right to sue. Maybe we decide we're going to litigate on behalf of not only you, but as I mentioned beforehand, kind of the American people as a whole. And just that the entire process with the EOC is absolutely free. When I talk about how much money that we get for individuals or things like that, we take absolutely not one penny. All the money goes to the individuals that are involved in the case. And if there's ever any money that is left over, we actually, as part of those processes, set aside that money for different organizations at times. So things that would help other people within the community. Remedies that are available are things like back pay or front pay. We talk about compensatory, punitive, or liquidated damages. So that's a lot of like pain and suffering damages. And then also punitive damages to make sure that things like that really never happen again. We always want to see if we can get hiring, promotion, reinstatement, if that's what the individuals want, the accommodations that somebody would need. Any other actions that would look at not having that type of discrimination occur again. So we'll try to do training. Sometimes we get really creative and we put in place like cultural competency training for the workplace. So sometimes we've had cases with like deaf individuals who aren't hired or who are treated poorly in the workplace. So not only do we offer deaf cultural competency training, but then maybe we offer ASL training classes as well to teach people how to communicate with their deaf colleagues. Sometimes we'll do things like in the Activision case, it had some pretty egregious sexual harassment occurring in the workplace. We had them offer therapy to individuals that were affected by it. And then, maybe there's policy changes. There's a lot of things like offering 800 hotline numbers where people could report things anonymously, maybe expert witness fees, court costs, and just different things like that, just to make sure that anything is redressed in the workplace that needs to be done. And then there were just a couple of questions that were kind of addressed where people were talking about, like, kind of where are we at with things like the agency as a whole. The agency has been around for 60 years, and we are continuing to stay here. There was an executive order that was signed back in January that was a little confusing for some because some people thought it diminished or it got rid of the EEOC, but it actually didn't get rid of. Yes.
Thank you. Just real quick. Somebody is writing on the screen again. Could whoever it is, please stop? Okay.
Oh, really quick, here is my email. I'm going to throw it here in the chat, and then maybe I'll stop sharing, and then that way we don't have to worry about the screen anymore. uh, Here, I'll put my email in the chat. Oh gosh, that's not my email, y'all. I forgot my own email address. Ignore the email on the slide. I will fix it later. My email is not Nikki. My email is Nicole. That is great. Okay, here we go. This way nobody can write on the slide. So I know there was a thing where, there was some discussion about, where we were at and everything. I will say that we're still here. There was some discussion at one point in time because in January, the president did an executive order that got rid of the Department of Labor's Office of Federal Contract Compliance programs, which did a lot of EEO work. And a lot of people thought because they did equal employment opportunity work, they got rid of the EEOC. They did not. We are codified by law. So it's really hard to get rid of us because we're codified into law. That the OFCCP was created by executive order, so it can be taken away by executive order. Um, we still have budget. Budget has been approved as it was standing as of last year. So we are going to be moving forward. As I said, we have about 700 people less than we did 2 years ago. So we are maintaining and we are going to continue as we always have. We are doing the same work we have always done, and we will continue to do it. We are passionate about the work and maintain that passion every single day. So we are here and we'll still be here. So I hope that you all continue to call us and work with us and know that we are here to work alongside you as well. So, any other questions while you got me here?
Michelle has. Okay, there you go.
Thank you so much for taking my question. So if we wanted to soundboard something with you, that's something that your schedule will allow, or should we file something first and then reach out to you?
So just shoot me an email. We'll set up like you and I can just set up a call. My
Okay.
schedule allows for that.
Okay.
So unless you are hitting your 300 days and then schedule that first. So I don't know, whatever is easier. Like over the next couple weeks, you and I can soundboard, but I don't want to tell you that if your 300 day is like tomorrow.
Okay, understood. Okay, I
Does
will
that
reach
make
out via,
sense?
it does. I'll reach out
Okay.
via email to schedule something with you. Thank you.
Great, no problem at all. Carla?
Yes, I'm interested in knowing like what type of, I guess, settlements have you done after you find whatever to be true?
Well, it depends on what it is.
Okay.
So part of that, it can be anything from, you know, $10,000 for a
Oh,
resolution
okay.
to something that's like, $10 million. dollars. It depends on
Oh,
how big it is. It depends on who's involved. It depends on the harm. It
oh,
depends on how many people. It depends on how long it's been going. I mean, there's so many factors that are involved. It depends on a lot of things. It depends if it went to litigation. It depends if it's just a mediation vehicle. It depends if we're changing law. It depends if it goes to the Supreme Court, if it's lasted 10 years. Like,
um,
there's lots of factors.
what if it's like a hiring discrimination type thing and the person who filed the complaint still wants to work with the company? Or what if it's like the pay? If a woman's getting paid less, if guys are getting paid $5 more and the woman wants to stay with the company, then is her pay going to get increased?
Yeah, so those type of things, what we would look at is we would be looking at what we would call that back pay. So we would want you to
Okay.
be paid back to what you were missing and then bring you up to the pay that you should be being paid at. And then
Mhm.
we would see whether or not there should be some compensatory damages because, you had been paid and there's a little bit of pain and suffering for what's going
Mhm.
on,
Okay.
right? But it wouldn't be, depending on that, it wouldn't be too much more than that, right? But now if you've been working there for 30 years and you've got $5 of back pay, $5 an hour of back pay for 30 years, that could be pretty petty. If you've been working there for a year, it's not going to be the same. So that's why I said everything really depends on where we're at, how long, etc. I worked a EPA case with a commission structure that was pretty insane because the female had such a great like selling, like she just sold amazingly that they kept lowering her commission structure because they were like, well, if she makes any more money, she'll make more than the president. And I was like, but that's not fair to her because now she's getting paid less than everybody else because, so it was one of those things. So she ended up making a lot of money in the like resolution of the case because they kept just lowering her commission structure so that she wouldn't make more. So those type of things, it's always just kind of depends on where we're at. So thank you for the question. All right. I think Tara's saying, hey, everybody, just don't forget to drop your email in the chat if you want a copy of the slides and the recording so that she can get that to you. Slides will have my correct email address. I cannot believe this is the type of day I apparently had yesterday is that I wrote the wrong email address in there. So
I have done the same thing myself in the chat, like my wrong email address and everything, wrong phone number. So yeah,
yeah.
it happens. Anyways, I want to thank you so much. If there are no more questions, I want to thank you so much, Nikki, for all the information that you provided tonight. And if y'all want to get involved in the Stewards Council or become a member of the Black Worker Center, I'm going to drop my information in the chat and you can reach out to me. Also, I'm getting all the emails. I'll be emailing out the presentation slides and the recording from tonight. And with that, I'm going to end the meeting and thank you everyone for coming.